Good afternoon, everyone. I want to call this meeting of the Early Learning Council to order for August 6th. We have, I think, at least one Early Learning Council member on the phone, and at some point we expect we may have an honorable appearance by our director, who is with her daughter, who is in labor at the moment. So we'll check in with and see if Jada is on the line in just a few moments. So welcome to the board, and let me ask Alyssa to call the roll, please. Present.
Vicki Bishop.
Present.
Janet Smith.
Present.
Dana Hardinati.
Here.
Eva Ripito. Here. Krista Rood.
Present.
Lynn Saxton.
Here.
Norm Smith.
Here.
Terry Talhoffer. Here. Roberta Weber.
Here.
Kim Williams.
Present.
Dick Licknell.
Here.
And Rob Saxton.
Here.
Great, thank you. Council members McGee, Tierney, Adair, and Yeswin have been excused for conflict reasons. And let me just take this opportunity to see if Jada is able to join us on the phone. Jada, are you there? Okay, that must mean there's activity. Another early learner. That's good. All right, well, welcome to those of you that are with us today. The purpose of this meeting is to consider temporary rules and revisions to our child care regulating rules. And if you are with us today and would like to provide public testimony, we will get to that. I think in about half hour to 45 minutes. There is a sign-up sheet which is just outside the room. You do need to sign up. I will give last call at some point for public testimony, and if your name is on the list, you'll be able to provide it. Just given the amount of testimony we anticipate today, we will limit testimony to 2 minutes, and Alyssa will serve as our timer. So if you could prepare yourself for that and really focus your remarks to 2 minutes, that would be useful. And again, sign-up sheet just outside the door. All right, so with that, I'm going to ask Duke Shepard from the Governor's Office to come forward with a message about our task today.
Thank you, Chair Curtis. Can you all hear me? Mm-hmm. For the record, my name is Duke Shepard. I'm a policy advisor to the Governor on Labor and Human Services, which has included for the past 3 years early learning. And I would like to, I'll keep my testimony within 2 minutes, I think, and provide a little history and then speak a little bit to what you're going to consider today. So just over 4 years ago, Pam and Lynn co-chaired a transition committee that summarized Oregon's child care system as not being focused on kids, and I quote, neither integrated nor accountable. And I think today you are acting to integrate and be accountable in a way that might be overdue. So since that report, we've passed 3 pieces of legislation, a couple budgets, added state resources, secured a Race to the Top grant, and changed our systems and contracts to get more integrated and more accountable and more focused on kids. Before July 2011, this council didn't exist. Before July 1 of 2013, there was no early learning division. And before July 1 of 2013, the Office of Child Care's regulatory responsibilities were in the Employment Department because the previous policy context was child care was first and foremost an employment support. And the policy direction from the governor and the legislature that you've all been a part of for the past 3 years is to change that child care is about kids first. It is certainly an employment support. That is a key value, but kids are the priority. And prior to July 1, 2013, this body didn't have line of sight into child care regulations. There wasn't a public body that set the rules. It was purely internal agency business. So this is consistent with your evolving role as the legislature has granted more authority to implement their policy direction. So the governor has asked you today to take up the issue of medical marijuana cards within the context of child care licensure for sites that are both home and center-based. We're asking you to provide parents with a basic assurance that a place licensed by the state to care for other people's children isn't a place where marijuana is being consumed, grown, or stored. Getting paid to take responsibility for the care and education of other people's children is not an entitlement. It is a privilege, and it is a privilege that is certified by the state. So this is not a judgment about medical marijuana. That judgment has been rendered by the voters. It is legal, and it is also regulated. So nothing in today's actions prevents someone from a medical marijuana card from embarking on any number of careers that they want that they can do with their debilitating condition. In theory, one could work in a child care center 8 hours a day, go home, have a medical marijuana card, do what they need to do to manage their condition, and go to work the next day, just like they can with other prescriptions, just like they can with alcohol. That's different than turning your home into a business and taking care of other people's children and being responsible for children. Again, caring for children is not an entitlement, not when it's other people's children. So the governor's asking you today to update these rules to really close a small loophole for a minuscule fraction of the child care licenses we have in the state, about 4,300. And this is a small fraction, and just really is closing a loophole. So on behalf of the governor, I want to thank you for taking this up today. I hope you have some good deliberations and get to a decision that will be best for Oregon kids and parents. Thank you.
Thanks, Duke. Are there questions for Duke from the council? Okay, thank you very much. I'm going to ask Cindy Hunt to come up. Cindy's legal counsel at the Department of Education, and council members, she will be walking us through the rules. They were in your meeting packet. And council members, I have a complete copy sitting here if you need to refer to something in addition to what is in your packet.
Thank you, Chair Curtis, members of the committee. My name is Cindy Hunt, and I'm the Government and Legal Affairs Manager at the Department of Education. I work in the Deputy Superintendent's office, and as Duke was saying, the Early Learning Division is now part of the Department of Education, and as such, I have the privilege of working across the agency with all of the divisions. And so that's what brings me here today.
I'm going to push this up.
Okay. When the Early Learning Division was established, one of the charges that it received under state law, and this is the authority that we are asking you to act under today, is that when establishing minimum standards for health and safety, the division is to consider all the basic requirements for the protection of children. As part of that, you are to consider factors that affect the safety of children and the care of children. In addition, child care providers are also charged with considering the health and the safety and the care of children. And so this is the authority, the statutory authority, the legal authority that you're acting under today. So in regards to the rules affect a couple of the areas that the Early Learning Division regulates in. The first of these is the Central Background Registry. All child care providers are required to be part of this registry. So part of the rules goes in, and there's been a lot of focus on the medical marijuana part of the rules, but first I'm going to focus on a slightly different area, which is the rules that go in and they amend and revise those rules governing the background checks for individuals associated with the child care facilities to enable the Office of Child Care to consider patterns of behavior in the absence of a conviction or finding regarding a child abuse case. So this clarifies and draws a brighter line, and so that, again, putting the health and safety of kids first and foremost, that when there's a history and not necessarily just a conviction, that's something that the office can consider when registering a child care provider. Okay. The other thing, though, that the rules do is that they go in and they amend 3 different areas, and those areas are for registered family child care providers, certified family child care providers, and certified child care centers. And they do it in a slightly different way with each one, but consistently from one to the next. So overall, what the rules do simply is prohibit individuals who hold a medical marijuana card from being a licensed child care provider. Now, one of the questions that's come up around this is, but doesn't state law allow folks to have medical marijuana cards? It does. But it does not necessarily address that those individuals can be licensed child care providers, just as Duke was just explaining. What the rules do is they balance the health and the safety of children against other rights under state law. The rules also prohibit individuals from possessing, storing, or using medical marijuana on the premises of a licensed child care facility. So, for example, if an individual has a family member with a medical marijuana card, They can have a family member with a medical marijuana card, but the family member cannot store medical marijuana on the facility. One of the reasons for this is some of the methods of taking medical marijuana look very friendly for children. Unlike some other prescription medicine, and if you picture other, prescription medicine, you might picture maybe pills or something like that in a bottle, a child-proof safety bottle, right? Often with medical marijuana, the delivery methods look like perhaps a box of chocolates, candy, cookies, brownies, very child-friendly sorts of delivery methods. Some of the other methods are things like lotions. Children frequently put on sunscreen. They may not know the difference between medical marijuana lotion versus sunscreen. These are some of the reasons that in the temporary rules that we require the child care providers to keep, to not have paraphernalia at the facilities. The other prohibition is on any individual under the influence of medical marijuana from being on the licensed child care premises at any time. So again, this was getting at, we could have family members who have medical marijuana cards, and they can lawfully, with those medical marijuana cards, partake in medical marijuana, but they cannot be under the influence while they're at the child care facility. The rules clarify the prohibition on possession and use of illegal controlled substances, and I should say other illegal controlled substances. Medical marijuana under the Federal Controlled Substances Act is still illegal. And as the governor has pointed out, there is a conflict, or a loophole, if you will, between the federal law and the state law. And so that was one of the reasons that he had asked you to close that loophole today. But these rules are treating other illegal controlled substances that someone cannot be impaired, and be caring for children. And that way, it's treating medical marijuana in the same way as other controlled substances. The rules also clarify that there's a prohibition on the consumption of alcohol by any individual in the home during child care hours or when the child care children are present. Again, alcohol is a legal substance in Oregon if you're over the age of 21, but we can limit, the time and the place that folks can be impaired with alcohol. For example, you also can't drive in Oregon if you're impaired with alcohol. We've also clarified the limitations on the use of tobacco products, including smokeless tobacco and e-cigarettes, which is some of our newer products out there. So you also cannot be using these types of products when children are present in the home. A couple of other aspects of the rules that have come up surrounding this topic is the rules also clarify what the definition of a child care premises is. There was a question about that, does it only include, in the home? And we clarified that it means the structure that's identified on their application, but also includes indoors and outdoors space not directly used for child care. So for example, with a family child care home, it would include space such as, outside in a yard, playground equipment, the garage, spaces like this. So we took the opportunity to clarify that. Additionally, in the rules, we've directed that no one can have access to child care children who has demonstrated behavior that may have a detrimental effect on a child. And there's been a question about, well, what do we mean by that? And so there's a couple of examples of what that could mean is that, for example, if an individual had committed harm against another vulnerable population, for example, or the elderly or a person with disability, that would be an example that we would see as someone who had committed a detrimental effect, that may have a detrimental effect on a child. If someone had committed or allowed children to harm themselves or each other in the presence of other children, that would be another example. So with that, the rules are temporary, and what that means is that they're in effect for 6 months or until they're replaced by permanent rules. 6 months takes these rules till right around January, and there is a ballot measure in Oregon that's going to be proposed in November about the legalization of marijuana. At that time, if it were to pass, this council will have a conversation about what that means regarding these rules. If it does not pass, the council will still have a conversation about what that means regarding these rules. The permanent rulemaking process, what it envisions is that there would be opportunity for public comment, a couple of months, a rulemaking work group. The rules would be posted on the website, sent out to stakeholders. They're sent to legislators, for example, the press. So there would be a complete and transparent public engagement on that topic. That's one of the reasons temporary rules are only effective for 6 months. And so we would anticipate, regardless of the passage or non-passage of the ballot measure, that would be the process that the council and the division would be, engaged in the next 6 months. So with that, I'm open to questions.
Great. Before we open it up for council members to ask Cindy any questions, I want to do last call for public testimony. So if you intend to provide public testimony and haven't signed up yet, I'd ask you to do that now. The sign-up sheet is just outside the door. We're going to move to public testimony after the council has finished asking questions of legal counsel. Council members, questions for Cindy? Rob?
Just one. Sorry. So on number 9 on each of these, so I just go to certified center, number 9. In the last line of number 9, it uses the word medical. I'm just thinking that we might want to strike the word medical. I don't want somebody to make the argument that it's okay to be under the influence of marijuana as opposed to just medical marijuana. Just like in number 7, you can't be under the influence of alcohol and be on the child care premises. I don't think we care about whether it's medical marijuana or marijuana.
No. We do have other rules that prohibit child care providers from having illegal drugs on the premises. And so marijuana that's not medical is illegal right now in Oregon under both state and federal law. So that's covered in other areas. And so I wouldn't recommend striking it because we're trying to be very crystal clear that, because one of the questions that's come up also is that, you're talking about illegal controlled substances, and under federal law, it's illegal controlled substances. Why did you call out medical marijuana? We want to be clear that, we're also trying to include medical marijuana, even though there's a state law that allows individuals to have medical marijuana cards. So that's why.
Good.
Yeah. But that is one of those areas that if the ballot measure goes a certain way, that we would be examining.
Council members, additional questions? Yes.
Thanks for explaining the rulemaking process too, and letting us know that there'll be a work group and more time. I just have a question. When I was looking at the proposed rules, I was wondering if there are broader implications outside of medical marijuana, like for example, confidentiality of other medical records or anything that we might need to be concerned about, or just things that we need to keep in mind for potential issues that might come up for permanent rulemaking.
Yeah, I mean, confidentiality of records is something that the Early Learning Division takes very seriously, because some records, they have children's records, for example. So regarding, those issues coming up, it would definitely be considered, it's been considered in the development of these rules, and it will be considered in the development of any permanent rules, both the confidentiality laws under, state and federal laws. But in any case, yes, so it would be considered.
Additional questions for Cindy? Dana, any questions for Cindy?
No, I'm good, thank you.
Okay. Anybody else? All right, thank you very much. Alyssa, can I ask you to grab the sign-in sheet? And while she's doing that, let me just note for the record, council members, we have 2 pieces of written testimony that have been submitted. Oh, thanks, Teresa. 2 pieces of written testimony that have been submitted, one from Becky Strauss, the legislative director for the ACLU, and the second from Mr. Leland Berger, an attorney with the Oregon Canon Business Compliance Council. And so council members, you'll have copies of these testimony in your packet as well. All right, so we're going to try to do this in 2 minutes or so, and the first person signed up for testimony is Anthony Taylor.
Thank you, Madam Chairman. My name is Anthony Taylor. I'm the Executive Director of Compassionate Oregon. We're a medical marijuana patient advocacy organization, and we are dedicated to protecting the rights of medical marijuana patients and their families. I might ask for maybe 30 seconds leeway in the time thing. There's
We'll
just
do our best there.
there's a lot of stuff.
It's a lot of pressure, isn't it? I'm sorry.
Well, it's not so much the pressure, but the amount of stuff that, really should be addressed adequately. As in Counselor Berger's testimony, he calls out whether or not this is actually legal or not. I would like to just say under the summary or revisions, you just can't prohibit individuals who hold a medical marijuana card from getting a license. That's stated clearly in the statute. Can't do it. Now, you can put some restrictions on their use in certain licensed situations, but you can't prohibit it from them. To make the reach to prohibit an individual from possessing, storing, or using medical marijuana on the premises, that may work if it's a non-home situation, but in a home situation where a registered card holder lives, perhaps you should consider making sure it's stored in a locked place. You don't make these kind of requirements for people that are using Vicodin. You don't make these kind of requirements for people that are using methadone. You just don't do that. The other thing is, I keep hearing that marijuana is illegal. In this state, medical marijuana is not illegal. So you have to take that into consideration. The other thing is that it says here, prohibit any individual under the influence of medical marijuana from being on the licensed child care premises at any time. So that means if I ingest a medical marijuana edible product, I can't go pick up my child. This seems kind of hard to nail down. The other thing is there are a lot of people that don't smoke cannabis to use it for therapeutic benefit. They ingest it. So you have to deal with that part of it as well. Just let me get my notes. So in Counselor Berger's submitted testimony, he talks about cannabigotry. That's a term that's kind of come on the scene in the last couple of years, and it's exemplified by the use of under the influence. Medical marijuana patients are not under the influence of cannabis, of marijuana. They're using it as medication. So, you don't say that somebody's under the influence of Vicodin or under the influence of Oxycontin. You just don't do that. You say they use it as medication, and it's a prescribed medication. So there's a lot of these sorts of things that need to be addressed.
So I'm going to give you your 30-second
Okay,
grace
real
period.
quick then. I would just like to also say that there has been a violation of the law in the release of the information of these people who are registered card holders. That's not allowed under the law, and only law enforcement people or authorized employees of the Oregon Health Authority are allowed to have access to that information, and only on a yes or no basis. Yes, they have a card. No, they don't have a card. Yes, this is a licensed and registered premises, but it's a really slippery slope if you start trying to, just say, you just can't do this. I understand the concern for public safety. I understand the concern for the safety of the children under the protection and supervision of licensed healthcare professionals. But again, they are licensed healthcare professionals. Or licensed daycare providers, I'm sorry. Let's keep that in mind as we proceed. Keep in mind 475328, limits on professional licensing and list of persons and locations disclosure. So thank you very much.
Next, I'm going to call up Sam Chapman, and while Sam is coming up, I need to correct something. It sounds like the council members did not have, and I apologize, did not have the two pieces of testimony in their packet that I
I'm gonna read
referenced.
them.
You're going to read them?
Yep,
All
they've-
right.
they've asked me to represent
In
them.
the meantime, I will pass these around.
Great, thank
All
you.
right,
Will we
let's-
have a chance to ask questions of the presenters? I know we're,
Sure. Did you want to ask a
Well,
question,
I'll come
Mr.
back,
Taylor? We can-
let me hear the rest of it, but
Okay.
I may go back to the first witness.
Sure.
Right.
Yeah.
Let's do that. All
Anthony's
right,
welcome
Mr.
to come on
Chapman.
up if he wants to. Yes, thank you, Chair Pam Curtis and members of the Early Learning Council. I'm going to start with testimony from Becky Strauss, who's the Legislative Director at the ACLU. Chair Pam Curtis and members of the Early Learning Council, thank you for your consideration of the below comments. I apologize I'm unable to attend today's meeting of the Early Learning Council. The proposed child care rules before you have only recently come to my attention. In light of our concerns of the proposed changes, I ask that you reject them outright, or in alternative, delay a vote to afford the council the opportunity to better be informed about the potential effects and hear from a board set of stakeholders. Voters approved Oregon Medical Marijuana Act in 1998. The OMA permits the use of marijuana for Oregonians suffering from debilitating medical conditions without being in violation of Oregon criminal law. The debate is long over in Oregon about the medicinal value of marijuana, yet the proposed rules unfairly and unnecessarily single out patients who medicate pursuant to OMA and would require these patients to choose between their medication and their livelihood. Current statute and regulations already provide safeguards so as to protect the safety of children in these particular child care settings. Most fundamentally, it is unclear why these additional burdensome regulations are needed. Why are OMA patients being treated any differently than patients taking other types of medication? The council should delay consideration of this matter until some of these issues can be cleared up. Again, I apologize for the brief comments and not being able to appear today. And then I'm not going to read Lee Berger's full testimony. Rather, I wanted to highlight the part of the Oregon Medical Marijuana Act which Mr. Anthony Taylor had already cited. It is ORS 475.328, which provides, no professional licensing board may impose a civil penalty or take other disciplinary action against a license based on the licensee's medical use of marijuana in accordance with the provisions of ORS 475.300 to 475.346, or actions taken by the licensee that are necessary to carry out the licensee's role as a designated primary caregiver to a person who possesses a lawful registry identification card. Beyond that, I also just wanted to echo Anthony's comments on this being a slippery slope. I'm curious as to what other types of medication and other instances where we would want to force people to choose between their business and their medication. I think, and I understand Governor Kitzhaber's move to regulate this. There were some instances that caused, quite a stir and some concerns, and I think those concerns should absolutely be addressed. But I do agree with Becky and her statement from the ACLU that I think there's more time and a lot more information to be discussed before a special meeting is scheduled a couple days before the meeting and all of the facts can be presented. I'd be happy to answer any questions if you have any.
Thank you. Norm.
So this is a similar question I would have asked to Mr. Taylor, but I'm curious because I think I sense from both of you, you recognize the dilemma that we're in. That,
absolutely.
Child safety is our predominant concern.
Right.
No instance that I know of that a child has been harmed yet, but we don't want to be coming in after the fact.
Sure.
Give me a scenario that would work as well as the temporary rules to assure that children would be safe.
Sure. As Anthony has also stated, I think that it would be reasonable to consider certain types of regulations that would restrict medical marijuana being on the premise if that is not an in-home daycare. It really, and once again, let me admit, I am not an attorney. None of this is legal advice. However, I do think that patients have a right to possess and use medicine in their own home. That does become a very tricky problem when it comes to daycare. I completely agree. I agree that we should not be putting children in a situation where they may potentially get into something like that, whether it's medical marijuana, whether it's other prescription drugs, alcohol, cigarettes, chewless tobacco, e-cigarettes, all of it. But in this specific case, allowing or forbidding people that have medical marijuana cards flat out, that just have them, to not run a daycare is a gross misstep, I believe, in this instance.
Thank you.
Additional questions? Okay, thank you very much.
Thank you.
Next on the list is Red Frost.
Good afternoon. My name is Omer Allen Frost is my legal name. Red Frost is everybody knows me by. I'm a medical marijuana patient, but I'm also a living liver cancer patient. Everybody else in my group is already gone. None of them were using medical marijuana. Am I alive because of it? Or just because I'm too stubborn to die? I don't know. But I do know that there's other people out there that are in similar positions that I am in that don't have money to get medicine. Not all Obama stuff is quite worked out here in Oregon. There's some of us that do need this as medication. My cancer doctor is not one of these fly-by-night drug people that give out these whatever papers you want to get with so many dollars. My doctor is a registered cancer doctor here in Oregon, and I have a prescription from him that doesn't say it's a prescription, it's a recommendation from a cancer doctor that's licensed in the state of Oregon that gives me permission to use marijuana. I used to have diabetes. I was taking lots and lots of medications, more than most everybody was. Today, I don't take any medication. I don't know why. Is it the marijuana? I don't know. I do know that I have done foster care my entire life, on and off. I have done infant care, juvenile care, child care, teenage care. The last child I worked with was out of Columbia County. That person graduated from the Naval School, did great, never did any drugs anymore in his life, because I'm the first person that didn't beat the crap out of him for doing something wrong. I let him get high, I set him down, I let him get over it, wondering what I'm going to do, and when he found out that he didn't get beat up, that's the thing that he remembers about me. Just recently, Columbia County contacted me to be another foster parent for this young man's nephew. I told them, because of all of this what's going on right now, I don't want to get in trouble. This is my daughter that's in trouble of all of this that's going on right now. All of this is BS because we are not supposed to be judgmental against the people like us. We're not judgmental against Vicodin. We're not judgmental against Percocet, Demerol, or anything else. One thing I do know, they say it's not medicine. The people that provided me my cancer pills was a company that now produces Sativex, which is a sativa medical marijuana plant that is used in the European countries that is now being tried to get here in America. In my box over here, I have every patent, every pharmaceutical company in the world that already has patents on medical marijuana. You have a male, you have a female, you can't patent them, but I can buy each of your plants, I can develop it, I can now patent my plant. Every single pharmaceutical people. If you want proof, I have it right there in that orange book.
Mr.
So
Frost,
medical
it's time for me
marijuana
to give
is
you
not
your 30
medicine.
seconds now.
BS.
Thank you.
I'm sorry,
No,
I
we're-
get passionate.
I can see that. It's a passionate subject.
It's something, I didn't have any medicine when I found out, I didn't have any money when I found out I had cancer. A lot of people helped me for free. I now provide medicine for other people for free. And the County of Yamhill and the County of Clackamas Sheriff Department knows all about my grow operation. They are strictly A-OK with it. Sheriff Crabtree out of Yamhill County. I spoke with him personally.
Thank you. Council members, are there questions for Mr. Frost? All right, thank you very much for your testimony.
Welcome.
All right, I apologize if I mispronounced your name. Next on the list is Charity Arujo. Did I say it right?
It's a rock.
Arajo, thank you.
Madam Chair?
Yes.
Is there somebody that just arrived, I know, that would like to provide testimony? I know that they missed last call, but they just arrived.
Yep, we can do it. We're doing 2 minutes, so you can sort of think about how you want to frame this in 2 minutes.
Okay, I know you say 2 minutes, but I think I deserve at least 4.
Sorry.
Okay, that's okay. For me right now, it's, everybody has their view of what's going on, but the fact is that this is basically about security versus privacy. It's not about, anything else. I was in my backyard. I did what I did. I have a question for every one of you. There were, do you guys know what OCC did to protect the children against people who have a medical marijuana card? Just curious. Do you guys know what they did to protect us, to protect the children? Anybody? I didn't think so. Okay. Before you guys make a decision on this, you really need to go ahead and take an opportunity and meet with the people of OCC. Give them a little bit of respect to have the opportunity to actually be people who protect children. Somebody had come up and said OCC is lacking in their position of being able to protect the children, and this is kind of what this is coming to. DHS is saying, or the state is saying, OCC didn't do what they were supposed to do. But I don't know if anybody knows, yes, 4 people had a medical marijuana in my home. Yes, my daughter runs that. Yes, they all use medical marijuana. Do they use it when they work with children? Absolutely not. OCC said we could. We do not. Do you guys know, out of the 4 people that were in my home, how many of us actually had taken it internally? We went right out and got drug test. Only 2 of us use it medically internally. Everybody else uses it in a rub. The young lady that sat here second, she stated that a danger is in the rubs and other forms of topical. That is not true. The research will show you rubs do not penetrate your skin. Okay, I'm not here to convince you on medical marijuana. What I am here to do is simply say, OCC came and checked and made sure that we were okay. Everything we did was under lock and key. They made sure of that. Not only did they make sure of that, but our provider, my daughter's certifier also said, you know what, we don't feel that this is enough either, so why don't you guys go ahead and add this and add this and add this, added layers of protection, okay? The fact of the matter really is that it's not really about the medical marijuana or whatever, it is that OCC is not being trusted to perform what they need to do in order to do their job to protect child care providers. And we're putting other people like DHS and that have completely different rules. It's not the child care division's fault, nor is it any providers. I don't know if
I'm sorry, it's your turn for your 30-second
Okay,
warning.
I'll end with this. Before I started my medical marijuana choice, 4 months before I got my card, I called OCC, and I did this through email because I knew something was coming up. 4 months before I got my medical card and chose to use. OCC could not give me an answer. They said, I don't know. We have to go to DHS. This is at a federal situation because you're getting funded states through the state. So we have to wait. It took almost, I think it was like 10 days before OCC was even able to come back and give me any form of a provision of, yes, this could happen. Okay, they did their job. They did their job, and they do their job. Give them a little bit of credit to do their job. Anyways, that's it.
Thank you. Are there any questions? All right, thank you very much. Welcome. Please, since we don't have your name, can you tell me what your name is and if you're representing?
My name is Erin Purchase, and I'm here today because I am an Oregon medical marijuana patient. I am also a pediatric cannabis therapy advocate. I advocate for thousands and thousands of children across this country and other countries as well. Many of you guys don't realize, but there are a lot of children in this world suffering from uncontrollable seizures, cancer, epilepsy, conditions that they should not have to suffer from every day. I have 2 children that suffer from conditions such as these. I have a child who's 9 years old that suffers from leukemia, and I have a 3-year-old that has a cyst in her brain and seizures. My hands are full, yes. I treat both of my children with full extract cannabis oil with great success. Complete, wonderful success. I don't use a lot of pharmaceuticals on them because they are damaging, and they're also scary. And the same goes for daycare providers using narcotic pain relievers or antidepressant pills. If I send my children to a daycare, these daycare providers are possibly could have to administer my children's medicines to them. The same medicine you're about to ban from them and tell them they can't operate their employment because they use a natural medicine that is, in a lot of people's opinion, better than the pharmaceutical narcotics that can really cause a judgment problem. As a parent of 2 little girls, I would trust putting them into the hands of a medical marijuana patient before I put them in the hands of somebody using methadone or morphine. I 100% would trust my children more with a medical marijuana patient as a daycare provider. Most of us are not irresponsible. I really don't think that there's going to be a daycare provider with bongs and joints sitting out on a table. First of all, nobody's going to take their children to a house that has that around. That's not at my house, and it's not going to be at a daycare house. There's a way to properly lock your medicine up. I don't think that most people lock their morphine and their Vicodin up. Usually it's in their medicine cabinet. I lock my cannabis up. I lock my children's cannabis up because it's something that needs to be properly administered by an adult and controlled. I think that instead of banning these people from using their medicine that is helping them, that we should instruct regulations such as it has to be under lock and key. These daycares are inspected for safety by the proper organizations. I believe that they should be allowed to use their medicine as long as it's under lock and key and the children have no access for it.
For just about 30 seconds.
Okay, great. And also I think it's a huge violation of these daycare providers' rights to put it in the newspaper, their names. This is medical information that's protected by HIPAA laws. You are releasing to thousands and thousands of Oregonians that these people are using medical cannabis to treat their conditions. I believe that these people are entitled to their privacy, and I believe that there has been a huge, huge mistake happening. Whoever checked that database against the daycare database and released this information to the paper, to the entire world, to see these people's names, it's a shame, because if my doctor did that to me, I would be mad. And that's that. Thank you.
Thank you. Are there any questions for Ms. Purchase? All right. Thank you very much.
Hi, my name's Jennifer Valley. I'm from Happy Valley. I'd just like to echo her concerns about HIPAA violations and confidentiality violations. The OMMP promises that our information will not be released. It sounds like there's been an abuse of the LEDS system here, and that's just my primary concern. I don't think that our rights should evaporate just because somebody yells marijuana. We should still have the same rights as citizens and as patients that we would have no matter what other medicine we use. Thank you very much.
Thank you. Questions? Yes.
Madam Chair, I guess I need a little better understanding of what the expectation of privacy is and the way the Act works to provide that privacy. Is this truly a HIPAA situation, first of all?
If I tell my doctor that I don't want my husband to know that I'm using medical marijuana, he cannot inform him of that without my written permission. So I don't think someone should be able to rummage about in a database and then publish that information without the patient's permission.
And in this instance, who did the rummaging that we're talking about here?
That's something I actually would like to know, because this is a very serious violation. We're talking about both federal and state laws that have been violated here.
So in just a moment, I'm going to ask legal counsel to clarify because there are two separate processes, and I think it's important for counsel to understand that. So did you have a follow-up
No,
question?
that just-
Eva, did
that's
you have a
helpful.
question that was not related to this? Because we're going to have legal counsel.
I was going to ask the legal counsel.
Okay. So thank you very much. Appreciate it.
Thank you, dear.
Cindy, can you come back up and address this issue, please?
I believe what the prior two speakers were referring to is that the Department of Education and the Early Learning Division received a public records request for the names of those child care providers that had a non-disclosable condition relating to medical marijuana as part of their license. But to be clear, and there were less than 5 of those individuals of the 4,000 and some providers. We treated that as a public records request under state law and also consulted with the Attorney General. And as such, it was determined that in our public records laws in Oregon, there's a preference towards disclosure unless there's a specific exception that says, state agency, you shall not disclose. There is no exception in our public records laws. Instead, it stated that we could do a balancing test. You know, is it within the public interest to release? And we came down on the side it was in the public interest to release the information. But to be clear, the reason that we had that information was not because a doctor violated HIPAA or because the Oregon Health Authority violated the Medical Marijuana Act. We had that information because the information came up either investigations that we did or the individual child care providers themselves had indicated that to the Office of Child Care. In regards to HIPAA, the Office of Child Care and the Department of Education is not a medical agency, therefore HIPAA does not apply to them, so it was not a HIPAA violation. One of the areas of state law that we are exploring potentially with our partners in the legislature is that right now the Office of Child Care does not have access to the list of individuals who have medical marijuana cards. And nothing in these rules would provide the Office of Child Care or the Department of Education access to that list. Instead, and I want to be clear, what the rules say is that if you have a card, you can't be one of the registered child care providers, but it doesn't give us access to the list to be able to check out that information. So in that way, it doesn't violate the privacy laws that are part of our Oregon Medical Marijuana Act.
Thank you. Council members, are there additional questions for Cindy? Yes.
I have
Rob.
one. So there's reference a couple of times referenced in Leland Berger's letter about ORS 475.32871 in regards to professional licensing board and civil penalties or disciplinary action.
Right.
Do you have any response to that?
Yeah. Well, first of all, because these rules would apply to those individuals who would be seeking license, renewal of licenses, reinstituting a license, and we would be either denying a license to those individuals, that is not a civil penalty, and that is not a disciplinary action. And that statement is also based on the advice of the Department of Justice. Regarding individuals who have a current license, again, there's a question under the law as to licensing organization. So to do this is not in violation of the statute that they cited to. Again, the actions under these rules are not civil penalties and they are not disciplinary actions. When the law uses the word civil penalty, it means something very specific. In other areas of the law, for example, it would say something like, if you violate this particular statute, the agency can assess a $1,000 civil penalty against you. That's an example of a civil penalty. This is not.
Additional questions, council members?
Madam Chair? Okay, if I could
Yes,
just
Norm.
clarify, you are saying that looking at .328, this is not taking other disciplinary action.
Correct. What the rules do to clarify is it says we're not going to issue a license to someone who has a medical marijuana card. So therefore, we're not taking disciplinary action, we're just not issuing a license to you.
But for those who already have both, is it considered a disciplinary action to perhaps give them a choice between
Right.
one or the other, their livelihood
Yeah.
or their medical marijuana? Is that not
Yeah,
disciplinary?
no, I mean, and the law is not crystal clear in this area, but based on the advice of DOJ, it is not, you know. And so, yeah, so it is not disciplinary action.
And Madam Chair, do we have benefit of an opinion from the Department of Justice?
The rules that were drafted for your consideration, council, were done with the counsel of the Department of Justice. Yes, Janet.
When Duke was explaining at the beginning of session, you said you can, like, you don't drink alcohol while you're caring for children. Were you also saying, but you could drink outside of those hours? And then is that the same for the use of medical marijuana, or is it, are we two different?
You're asking for clarification
I'm asking
from
for
Ms.
clarification.
Yeah,
I'm not
let me,
asking Duke,
let me
I'm
give you,
making sure I
yeah,
understood
let me
Duke.
give you some clarification. So, for example, if you're the child care provider themselves, you can't have a medical marijuana card and be a registered child care provider under these rules. So it's not talking about if you're doing it, it's talking about having the card. So if you are a family member, you could, but you can't be impaired and in the facility. It's not regulating outside of the facility. Yeah.
Okay. Yes, Bobby.
Cindy, this is very confusing when you get to home-based care, but my understanding is we regulate facilities, not people. Is that, my first question, is that accurate? And then my second question is, if it's accurate, how does that relate to this whole question?
Yeah, we regulate both facilities and people.
Okay.
You know, the facilities are licensed and registered and certified, that's correct. But in regulating the facilities, you know, and when you look at some of these rules that are in front of you, it talks about no person, you know, at the facility may be impaired and that kind of thing, and it's directed at the facility. But in doing that, you're also regulating the action of individuals.
Thank you. Additional questions from the council?
I just would thank Cindy for the clarity.
Yes, thank you. All right. Oh, yes, Eva.
So maybe it's kind of going off of what Bobby's question was. Am I not remembering this correctly? But for in-home childcare, there are areas that are designated for the childcare area, you know, like the outside and then the inside, and then there are other places that are off limits that are not included in the childcare. Is that the case, and is that?
Yeah. I'd like to draw your attention, and this is an issue that's come up, is what is meant by the premises. And in the rules specifically, and this is a new addition in the rules, it states, yeah, it means the structure that is identified on the application, and I think that's, Eva, what you were referring to, including, though, indoors and outdoors and space not directly used for childcare. So within these applications, the individuals will be designating space, and that space could be outdoors as well. But yeah, we, in the rules, we clarified, though, that we do mean the entire premises, not just what might be within four walls.
Council members, additional questions for Cindy? Stand by when, oh, I see.
I have a follow-up
Not even
question
stand
for
by.
Cindy on my first question. There's been, in the testimony, several references to the term professional license. I don't know the legal definition of that term, and you were making
Yeah.
differentiation between the Early Learning Division and the Department of Ed. So can you
Yeah.
talk about to what makes something a professional license, and how does that relate to what we do for childcare facilities?
Wow. You know, the question of what is a professional license under the Medical Marijuana Act, I believe, is kind of an open question. And so that's part of what's at the crux of this. And so I think earlier I referenced to some conversations we're having with our partners in the legislature. That could be one of them. So that's part of it. But, you know, the other piece, and I'd be remiss if I didn't say this, is that often when folks cite to an area of the law, they like to cite to it and try to cite to it with blinders on. But we also have other areas of the law that we need to talk about today, and that's a direction to all of you, you know, to set standards for health and safety of kids. Those are laws as well. When we look at the Medical Marijuana Act, it doesn't talk about doing medical marijuana or having a card around children. Your laws specifically talk about standards, high-quality childcare standards, and so both of those, under court's analysis, they would tell you that you need to give weight to both of those if you can. They're equal. And so, you know, to only look at the Medical Marijuana Act with blinders on and only read it within its confines would not be what a court would do. They would look at also the other standards and say, yeah, you know, they need to balance against, you know, safety of children and that kind of thing. And so the same could be said for, you know, when we look at the meaning of what does it mean professional licensing under Medical Marijuana Act. That would be balanced against the other charges that professional licensing boards would have. So that's what makes this area of the law fascinating, actually, in some ways.
Thank you.
Additional questions for Cindy? Yes, Janet.
Can a teacher have a medical marijuana card? I know everything is brand new. I mean, we're really not having a roadmap, but
no, that's a fair question. Yeah, you know, I do not know of any laws that would specifically prohibit a teacher from having a medical marijuana card. Having said that, all teachers in our public school system hold a license from the Teacher Standards and Practices Commission. The TSBC does have standards. None of them currently that I'm aware of call out medical marijuana usage or cards or anything of that nature. But they do have professional standards. So if a teacher arrived in class impaired or otherwise could not do their job, there would be policies and standards and so forth that would apply to that.
Well, I know most school districts have those
Correct.
for being impaired, but you could have the card right now.
Yeah.
Probably.
And just to be clear, the rules that are in front of you do not apply to K-12 teachers.
Council members, additional questions for Cindy at this time? Okay, thank you. Now stand by, because we may ask you to come up and clarify again. All right, council members, what are your thoughts about these proposed rules at this time?
Are they considered before us now?
They are considered
Okay.
before you now, and we will take a motion either now or later, but we can begin our deliberation at this point.
I will make a motion for the purpose of the deliberation that we adopt the proposed amendments relating to controlled substances, including medical marijuana, and that we adopt these proposed temporary rules.
Thank you. Is there a second?
Second.
Discussion, council members? Yes, Eva.
So, my only concern is much broader than marijuana. So I'm not trying to say that we shouldn't pass these today, but I look forward to a very robust discussion before we make them permanent. I have some concerns about the broader implications, especially with the premises, because especially for in-home providers, we're opening up their entire house then to be subject to the business. And I'm just wondering what I don't know what the answer is right now. And so that's what my concern is should they have a little bit of area that's theirs? So.
Thank you. Additional comments or thoughts, council members?
I guess I would go farther even from what Eva said. I had thought about this when we anticipated this meeting about people who are on certain other medications where the bottle does say, can cause this, this, or this. And I don't know where we go from there. And I know in some, I believe I understand that there's some pain-killing medications that if you really have a pain, you wouldn't become addicted to it necessarily. I know addiction is a whole nother ballpark, but I think we have to do something on this, and I also feel like I wish I had more information and knowledge, probably knowledge.
Thank you. Additional thoughts, council members? I do want to clarify, and then I'm going to ask Cindy or somebody from the division to tell me if my understanding is incorrect, but I do want to clarify something, which is that we, council members, we have a statute that governs us by virtue of the fact that we now have the Office of Child Care as part of the division that we are the policy board for. And those statutes require us to establish health and safety standards for children who are in that level of out-of-home care. The statute also requires providers to ensure health and safety of kids, but it requires us to establish health and safety standards, which the division did do. And the division has been regulating and includes some of the kinds of safeguards that our testifiers have mentioned and that some of us have mentioned as well, separation or locking or whatever it is. It has included those kinds of things. And part of the reason that we are here is that it hasn't worked. And we have had violations of those. And so we have a loophole that needs to be closed. And so the proposed loophole, or the loophole is proposed to be closed in the way that is in front of us with these regulations. So am I incorrect in that? Got that accurate? Okay, so just to clarify, we have regulations that have tried to address these issues. It hasn't been successful. We've ended up in a situation where we need to be crystal clear about what our intent is with those health and safety standards, and the proposed rules are in front of you, or the proposed changes to those rules are in front of you now. Was there, Eva? Okay.
Question?
Yes, Dick.
Oh, me.
Oh, you calling the question? I'm sorry.
Yeah.
Council members, are we prepared to vote? Do we need more discussion? Dick is calling the question.
If I may, first of all, I've learned a lot today. And I really appreciate what people have presented to us because, for the most part, it's largely new information for me. And I thought it was done respectfully and well done. I guess I would say that there's nothing that isn't open for further discussion, but the starting place, I think, is a set of rules that will require a deeper dive into the details. I think my own position, at least as I arrived in the room, and I still think it's the one that kind of controls my head and my heart, is that we can't and should not err on something in our purview that has to do with health or safety of children. Now, whether we've got it right in this document, I think that remains to be seen. But it is the set or the proposal that we have that I think is the starting place. And that's why I will support it today, but I don't know where I'll be on it in 6 months.
Thank you. Bobby and then Eva.
The part that and it maybe can be answered by Cindy, is how we're dealing with other controlled substances, such as that have been mentioned today, that also impair. And I have had to sit on DUI trials, I'm sorry to say, because it's a miserable experience. But it doesn't matter how you get impaired. The law is impairment. And so the fact that you were taking a prescribed drug doesn't absolve you at all in a DUI trial. It's the question of impairment. So my question that I just simply don't know is, are our rules consistent for anything that would impair the judgment of a person responsible for a group of children?
I have a simple answer for you, and I'm going to just read from the rule on, for example, for certified centers, 'cause I think it's pretty clear. So the provision says, no one shall possess, use, or store illegal controlled substances on the child care center premises. No one shall be under the influence of illegal controlled substances on the child care center premises. And then the paragraph under it says the same thing, but insert medical marijuana for illegal controlled substances. So they're being treated the same.
Thank you.
Eva?
I just wanted to echo what Norm said. So you're here to that. But
So,
Yes. Janet?
I am confused more. So, like Vicodin or the medications that were mentioned are legal controlled substances. And so I guess that's where I get confused. I understand it's illegal at the federal level. It's legal, medical marijuana is legal at Oregon's level. So maybe we should go farther and do the other medications. I guess I will say I would go for this for the short term, but I really do want to understand better and do right by the children first, and then people who are making this their livelihood.
Some controlled substances are illegal and you cannot get a prescription for them. Cocaine would be an example. While other controlled substances, you can get a prescription, and then, I don't have an example off the top of my head. Vicodin, I think, has been mentioned. So in the rules, we're addressing illegal controlled substances specifically, not those that would be legal to possess primarily under federal law. The other controlled substances that are legal to possess, those are addressed though in other rules of the child care. So for example, you cannot be impaired, if you're impaired with Vicodin or something like that, there are other rules that address that.
So again, just to clarify, there are rules that address legal controlled substances. Yes. They're just not before us today because this is part of the, we're amending the illegal controlled part.
Exactly.
Because of the illegality of the federal law.
I get that. It's
Okay.
just
Yeah, so they are addressed. So, but I think what Janet is trying to say is that when we come back and look at these in 6 months, presuming we do adopt them today, we should look at the whole package and be sure that we are not just being consistent to Bobby's point within these rules, but being consistent across all rules. And Cindy says we are, we just don't happen to have those in front of us today, but we should look at the package.
Yes.
So I'm looking at staff to say that the council really wants to look at the whole gestalt of it all. Okay, thank you very much. Council members, additional questions or comments that you want to make before we call the vote? Sorry, our public testimony is finished. Council members, additional comments or questions? Okay, so we have a motion before us that adopts these proposed temporary rules. If we pass this motion, these rules will be in effect for 6 months, during which period of time we obviously are going to have a ballot measure in front of us, and we will do the due diligence that includes some of the points that council members have raised today, and I'm sure many others that we haven't even thought to raise yet today. All right, I'm going to ask you to take a voice vote, please, Alyssa.
Pam Curtis,
Aye.
Vicki Bishop,
Aye.
Janet Doherty Smith,
Yes.
Dana Harganani,
Aye.
Eva Ripito,
Aye.
Krista Rood,
Aye.
Lynn Saxton,
Aye.
Norm Smith,
Aye.
Terry Tallhofer,
Aye.
Roberta Weber,
Aye.
Tim Williams,
Aye.
Dick Withnow,
Yes.
and Ross Saxton.
Aye.
Great, so council members, this has passed and the temporary rules and by unanimous vote of the council. And what we, I think, have done today is to put these rules in place to make crystal clear that we think the health and safety of children is paramount, and that we have 6 months of work to do to look at the gestalt of these rules along with the rest of our child care licensing rules, to be sure that they say what we want in terms of the paramount health and safety of children, and that we are being consistent across all rules. So thank you very much. All right, council members, is there anything else that we need to consider for the good of the order today? Eva?
I was just wondering if we could maybe have at some point a panel discussion about how this may or may not work. Yeah, I do have some concerns. I'm worried that, we're limiting people who might not have a whole lot of healthcare options and still need to work. But I also don't want children to be at risk, obviously, so.
Well, and I think what we may do, council, is to get started, but to hold off until we see what happens with the ballot measure, so we know what is under our consideration at this point. So I think there are things that we can do to get moving on this, but we probably will not do those kinds of things until we know exactly what it is that we're dealing with.
That makes sense, thank you.
Okay, yes, Vicki?
Who will have the burden of enforcement, the additional enforcement?
Yeah, so council members, I don't know if you heard, the question is who will have the burden of enforcement? So there is an enforcement and compliance division within the Office of Child Care, and that is the unit that will have the enforcement of these rules. Additional questions, council members? I have one announcement if there are no additional questions or comments from you all. Okay, and that is that beginning this week, we are convening a cross-section group of experts to help us really refine the metrics that we are wanting to hold the hubs accountable for. So we have the 3 big goal areas and we have some placeholder metrics, but really probably none of us are fully satisfied with all of those. And so that work group rolls up its sleeves and gets very active, hits the ground running this week. So I just wanted you to be aware. I anticipate that you'll get an update at our September meeting, but we'll be at work for about 6 months trying to refine those with lots of input from our providers and lots of input from our local hubs. So, all right, yes, Bobby.
Are we doing a retreat? I just realized I need to protect my calendar, and I didn't have dates.
So I can't see
Protecting
Megan's
my
face, and
calendar.
she's bowing her head. So I'm anticipating that we are having a retreat on those days. But we haven't sort of, because we're in the process of staff changes, and I'll check to see if Jada's logged in here yet, but because we're in the process of that, I don't know the complete answer, but I'm anticipating that we're going to have some sort of retreat, and you should hold those dates.
10th and 11th?
10th and 11th in Portland, location to be determined.
Could we, just in case, poll the group to
Oh,
see?
absolutely.
Because one of those days is impossible.
Okay, well, Alyssa, can you make that happen, or somebody will make that happen? Okay, great, thank you so much.
September.
All right, yes, September, that's correct, but we've got a lot of work ahead of us. All right, anything else, council members, for the good of the order? Was there somebody else that I mentioned, or missed? All right, Dana, thank you for holding it on the phone. Jada, did you join us? All right, that's gotta be baby news. All right, we are adjourned.